I would like to open by first welcoming the family of Miguel Descoto, his niece, and son, and various relatives. But I always used to think of Miguel's family as this extremely extended thing, which included, you know, pheasants, dogs, anything else that sort of was in the house, and I knew it for so many years. I'd like to extend a warm welcome. There are supposed to be 10 or 12 of the diplomatic corps, primarily from the Caribbean, who will be honoring Miguel by their presence if they get here. The representatives of the Nicaraguan mission, Patricia and Alina, who are at the elevator waiting for people. A particular thanks to Martin Flaherty, who will be one of the responders, and to the Leitner Center of this law school that is co-sponsoring this event. The Institute for International Humanitarian Affairs will publish the proceedings, as I mentioned. There are a few students here today, but they are the ones that I would like to welcome most warmly. And then I'll introduce Richard Falk, who flew in from Turkey yesterday to be with us today because of his work with Miguel over many, many years. The inaugural conference, this inaugural conference, celebrates an important anniversary in international law. It was 20 years ago, a little over that Miguel Descoto, as you're going to hear, determined to sort of assert the rights of a small nation against those who would suppress it, block it, crucify it. I was a doctor, and I had worked with Miguel for many, many years, first when he was a missionary in Chile, and I discovered at that time his incredible ability to move from being a missionary to being political activist, diplomat, or anything else that came into his head. And one time I remember he discovered that the then Secretary General of the UN and the President of the General Assembly happened to be patients of mine. That was the opening to saying, wow, we'll get Eduardo Frei out of house arrest. And he did it by just organizing a conference with me, asking the people at the UN. And it worked. The Chilean new administration government got embarrassed. They wouldn't, you know, suppress Mr. Frei's coming up, and he lived in our apartment for a week or so around the conference. It was one of the early books published by Orbis Press, which was one of the great things. We have a representative, I should have introduced the representative Marino Falk is here today, who with the sort of innocence or direction of Marino Falk said, what is next year's lecture going to be on? I was just barely getting through this year's lecture, Paul, but we'll go to next year's lecture too. And I hope that this will be an annual lecture, and Miguel's range of interests and his importance goes so far that I could think of a lecture on pottery or Latin American art or liberation theology, but we'll have next year's lecture, and it will become part of a series, I think. I headed the health services in Nicaragua after this 1972 earthquake. But I had known Miguel before, and while I lived in a tent with General Somoza for 6 weeks, I would go in the afternoons to meet with Miguel and meet the growing number of priests, poets, and writers who became the group of 12. So while Daniel Ortega and Alberto and Thomas Borges were up in the hills, it was Miguel and these other people who were the thoughtful intellectual background, and they would meet again in our apartment over and over again for months, plotting the establishment of a more just and human state, which ended up with to be Nicaragua. I think of so many things as I was preparing this one. Miguel, and as many other, and I was his physician and his friend, and couldn't come up to my wife's funeral memorial service because he was persona non grata in America at that time. But he, one time, and I thought of this when I was writing the other night, went on a fast, and I'm talking of a serious fast. And I had some doctors that I knew who were dealing with Bobby Sands up in Longkesh prison. And it's a very specific thing. You get to day 18 and your kidneys start to go, and you get to day 20 and something going. And I remember coming home to the beach one night, and I'd stay in touch with Miguel and the various people down there. He had gone into a sort of a barrio. He was surrounded by blocks, as far as I can remember, of nuns and people praying and priests, and he was there. And I came home one night and said to my wife, you know, it's getting very close, I better go down. And he was refusing on the phone to follow even medical advice, but I came down, and as I walked in the door, he said, I knew you'd come when the time was right. I said, well, did you start eating? He said, yes. So he started, and he loved to eat. Let me tell you, I could tell stories of asparagus and smoked salmon in the car. So Miguel had this great love of everything in life. But one of the ones, in the title of today's talk, was devised in a conversation that I had with Richard Falk, who was a very old friend and contributed years ago to one of my books on traditions and values. And Richard, and I shouldn't take any of his talk away, but said to me something really magical, that he had never met anyone or didn't know another case before the International Court in The Hague that started with legality but focused on morality and ethics. And so we came up with this, I think, lovely title of the spiritual sources of legal creativity. And it seems very appropriate at Fordham University, a Jesuit school, that this first Miguel Discoto lecture is to be delivered by Professor Richard Falk, one of the world's great authorities on international human rights and humanitarian law, and a great friend of Miguel Discoto's. So I'm going to give you Professor Richard Falk.
Thank you, Kevin. Friends, distinguished guests, members of Father Miguel's family, it's a humbling honor for me to give this inaugural lecture dedicated to a great human being who inspired and touched the lives and work of so many of us in this room. Kevin is among those here who had an intense and sustained friendship with Miguel. Kevin is also a person with his own inspirational gifts, and I remain deeply grateful to him for originally bringing me into contact with Miguel. Others here can speak more knowingly about the person, and Kevin has already done so. I will only say that Father Miguel exhibited a remarkable quality of moral radiance that was immediately apparent to all those fortunate enough to cross his path. The only person in my experience who possessed a comparable depth of being was Nelson Mandela, with whom I had a single and brief yet memorable encounter. The title given to my remarks that Kevin already alluded to, I have to admit I imposed upon myself, and it strikes me now as far too ambitious. But it does reflect the most enduring and empowering dimension of my association with Miguel, and does seem appropriate to reflect upon in the venerable academic atmosphere of the Fordham School of Law. My point of departure is this: if we believe that justice is the proper end of law, we must work to overcome the transactional and calculative mentality that dominates lawyering and thinking about law. Such a mentality limits the role of law to the domain of the feasible. I'm fully aware that this is an unconventional approach, elevating the moral imagination and what I would call utopian realism to the mainstream understanding of law as essentially offering a suite of techniques for problem solving and reducing politics to the art of the possible. It is this kind of ethical radicalism that made the life of Miguel so exemplary for all those who had the good fortune to be working or in close contact with him. Whether it was his role in ministering to the poor or challenging the high and mighty, whether acting in a pastoral capacity or as a man of the world, whether as an ardent Nicaraguan nationalist or a passionate citizen of the world, or in my preferred language, Miguel was an exemplary citizen pilgrim. Let me preface this inquiry into the spiritual sources of legal creativity with a general remark that pertains to international law. International law may be almost alone, or let me put it this way, I may be almost alone in believing that international law is the field of law that is currently most relevant to the ultimate survival of the human species. And yet, this branch of law continues to be denigrated, evaded, and violated by the most powerful governments on the planet, not least of which is our own. Wherever it obstructs the interests that these powerful states are pursuing in the world. And yet, viewed from another perspective, outside the domain of vital interests and security policy, international law in relation to trade and investment has basically protected the interests of the rich and powerful, while shackling the poor and vulnerable. In other words, international law has this dual face. It bends to the will of the militarily powerful in ways that endanger the human future, while often cruelly imposing accountability on the weak. And it's really important to understand that duality, that it is at once a necessary part of trying to empower the human condition in such a way as to address the global challenges that threaten our future. But at the same time, it is an instrument that can be used for oppressive purposes. All law, in a way, has this characteristic, but most law functions within an institutional setting that allows it to be enforced in a relatively objective way. International law is much more vulnerable to geopolitical manipulation. And it's that vulnerability that is exploited by the powerful at the expense of the weak and small. At the founding of the United Nations, a perceptive Mexican diplomat caustically observed, and I quote him, "We have created an organization that regulates the mice while the tigers are free to roam the world." And this remains, unfortunately, a feature both of international law and of its most institutional embodiment in the United Nations. It is against this background that Miguel de Scoto's spiritual wisdom creates a contrast with business as usual in the world of realpolitik. Even the most ardent global reformers regard the criterion for constructive action as a realistic appreciation of achievable limits, what I identify as horizons of feasibility, which is the way most who operate within the domain of political power operate. we're living increasingly in a world in which there are growing gaps between what is feasible and what is necessary. And it's important for that reason to also take account of horizons of necessity. Adapting to climate change in the age of Trump underscores this menacing gap between feasibility and necessity. As a diplomat, Father Miguel was almost unconcerned with feasibility, and this alone set him apart from most of his peers, but deeply sensitive to the imperatives of necessity, and even more so to the moral and spiritual imperatives of doing what is right under whatever circumstances he confronted. And for this reason alone, he was most responsive to what I would identify here as horizons of spirituality. He was motivated by a belief, undoubtedly reflecting his religious faith, in the potency of right reason, and conceived of international law as a crucial vehicle for realizing such a vision, engaging in a kind of politics of impossibility. In other words, turning the conventional wisdom about politics as the art of the possible on its head, and being challenged and challenging the existing structures of authority by doing what others regarded as impossible. And I think there's a real space for what I call the politics of impossibility, which itself is kind of doing a certain violence to our conventional understanding of language. But in this politics of impossibility, considerations of justice outweigh calculations of feasibility and even overcome the obstacles of geopolitics that weighed so heavily on the trials and tribulations of his country and their people. Let me illustrate briefly by reference to the historic case that Nicaragua brought against the United States in the early 1980s at the International Court of Justice in The Hague. To conceive of such a legal initiative was itself a daring legal flight of moral fancy, to suppose that beleaguered Nicaragua could shift its struggle from the bloody battlefields of his country, where U.S. intervention and insurgency against the Sandinista government, of which he was then foreign minister, that could be shifted to the lofty legal terrain that had been crafted to reflect the values and interests of dominant states, the geopolitical players on the global stage, was really only possible by recourse to the moral imagination. But more than this, it was a brilliant leap of political imagination to envision the soft power of law neutralizing the hard power of high technology weaponry in a high-stakes ideological struggle being waged in Nicaragua in the midst of the Cold War. Such an attempt to shift the balance of forces in an ongoing armed conflict by recourse to international law and the World Court had never before been made in any serious way. This was a novel initiative in that sense. It was a David and Goliath challenge that the World Court, as the highest judicial institution in the UN system, had yet to face in a war-peace context. And it turned out to be a test of the integrity of the institution itself. To recall the situation in Nicaragua briefly, the United States was supporting a right-wing insurgency, the counter-revolutionary remnant of the Somoza dictatorship that as a family had cruelly and corruptly ruled Nicaragua between 1936 and 1974, on behalf of corporate America, the era of banana republics. Leaving the country in impoverished ruins when their long-lasting dynasty finally collapsed. The Somoza-oriented insurgents were known as the Contras and were called freedom fighters by their American sponsors because they were opposing the Sandinista government that had won a war of national liberation in 1979, but was accused by its detractors of leftist tendencies and Soviet sympathies, which was an ideological formula during the Cold War that validated intervention and crushed the right of peoples to exercise their inalienable destiny of self-determination. And it was, in this sense, overlooking the reality that the true affinity of the Sandinista leadership was with the teachings of liberation theology rather than with Marxism. The United States, via the CIA, was secretly training and equipping the Contras and quite overtly committing acts of war by mining and blockading Managua, Nicaragua's main harbor, and its lifeline to the world. It was these interventionary undertakings that flouted the authority of international law and the UN Charter. Father Miguel addressed the UN General Assembly in his capacity as Nicaragua's acting foreign minister, describing the conflict with some well-chosen provocative words, and I quote, "It is obvious that the war to which Nicaragua is being subjected is a US war, and the so-called Contras are merely hired hands serving the diabolical objectives of the Reagan administration." Later in the same speech, he condemned the US government for appropriating an additional $100 million to what he called, and quoting again, to finance genocide against our people. I quote this language partly to show that Father Miguel's spiritual nature did not always mean a gentle demeanor. As here, when deemed appropriate to the situation, he relied on an undiplomatic candor and a fighting spirit to get his points across. He was also insistent on using such occasions to talk truth to power and to lay blame and responsibility for the torment of the Nicaraguan people where it belonged, however impolitic it was to do so. Without going into the details of the case, it was possible for Nicaragua to lodge such a complaint against the United States because the US had agreed at that time to accept the authority of the World Court if the other side in an international conflict was also similarly obligated. On this basis, Miguel, in his role as foreign minister, perceived two things: that the sovereign rights of Nicaragua were being overridden in flagrant violation of international law, and secondly, that the World Court was supposed to provide countries, whether strong or weak, with a non-violent option to resolve international disputes. And that this was to be a contribution to world peace that the US had itself earlier championed. It may not seem so unusual for a small country to take advantage of a potential judicial remedy, but as I said earlier, it had never happened before. No small state had gone to the World Court to protect itself against such military intervention. And to do so on behalf of a progressive government in the Third World in the midst of the Cold War seemed to many as like a waste of time and money that Nicaragua could ill afford. It is here one begins to grasp this revolutionary idea of relying upon the spiritual sources of legal creativity. Father Miguel was convinced that what the United States was doing was legally and morally wrong, and that it was an opportune time for the mice to fight back against a predatory tiger. It was, in other words, to act by reference to horizons of spirituality. Yet this does not mean that Miguel would ignore the pragmatic dimensions of effectiveness. Nicaragua managed to persuade Harvard Law professor Abram Shays to act as their head lawyer. This was a brilliant tactical move that I applauded at the time, even though it meant that as Nicaragua's second choice, I lost out. Aside from being a first-class international lawyer with a high global profile, Shays had previously served as John F. Kennedy's legal advisor and close confidant at the time of the Cuban Missile Crisis. The symbolism that Shays provided could not have been clearer or more appropriate. As could have been expected, the Wall Street Journal actually described Shays in an editorial as a traitor for accepting this professional role. I had the opportunity to work with Shays and Father Miguel in the Irish-American Center here in Manhattan that was operating under the benign tutelage of none other than Dr. Kevin Cahill. We worked hard for several days as a team, developing the arguments both as to the authority of the ICJ to adjudicate, called jurisdiction by lawyers, to be decided in a preliminary decision, as well as on the substance of Nicaragua's allegations. What was so impressive to me then, and even now, almost 40 years later, is that this effort to combine a somewhat utopian, motivated legal undertaking with a practical mastery of the technical dimensions of the case constituted the essence of what I would regard as spiritually grounded yet worldly wisdom. The outcome of the Nicaraguan narrative is too complicated to describe properly, but in short, counsel for Nicaragua persuaded the court that it had jurisdictional authority, at which point the United States petulantly withdrew from the proceedings and even renounced its acceptance of what is called compulsory jurisdiction, meaning that no state in the future could ever commence such an action against the U.S. government, and it too was foreclosed from proceeding against a state against which it had legal grievances. This has been a lasting effect of the Nicaragua case, and it has weakened the role of the ICJ and of international judicial authority generally. In one sense, the U.S. withdrawal was understandable for those whose behavior is guided by what I earlier called a calculative mentality. It hardly required a legal genius to anticipate that if the court had the authority to decide, then it would certainly rule in favor of Nicaragua on the substantive issues, given the sweeping prohibitions of international law and the UN Charter against non-defensive uses of international force, except in situations of self-defense against a prior armed attack. What was further interesting from a jurisprudential point of view was that despite the boycott of the proceedings and the denunciation of the jurisdictional finding, the U.S. quietly complied with the principal finding in The Hague, namely that the naval blockade of Nicaragua's harbors was unlawful. As would be expected, the U.S. government never acknowledged that it was complying, nor did Nicaraguans dance in the streets of Managua. But the cause-effect relationship was clear. there is a reality to the expression, the force of law, and the U.S. government, even during the Reagan presidency, did not want to stand before the world as defying the law, even international law, perhaps especially as it was struggling at the time to win the legitimacy war being waged against the Soviet Union when it came to upholding international law and promoting human rights. In other words, it had an incentive to be seen as a country supporting international law because it wanted to show the contrast with the Soviet Union as a country, as an outlaw, as an international outlaw state in relation to law and human rights. For me, this Nicaragua experience was a compelling example of Father Miguel's achievements that arise from his deep commitment to the horizons of spirituality and decency. It was far from being the only instance. Let me mention two others very quickly. One of my other connections with Miguel was to serve as one of his special advisors when he was president of the UN General Assembly during its 63rd session, 2008-9. As is now the case, life could become difficult for any leading UN official who openly opposed Israel. Father Miguel was deeply aware of the Palestinian ordeal and unabashedly supportive of my controversial role at the time as special rapporteur, as UN Special Rapporteur for occupied Palestine on behalf of the Human Rights Council in Geneva. When I was detained in an Israeli prison and then expelled at the end of 2008, Father Miguel wanted to organize a press conference in New York City to give me the opportunity to explain to the world what had happened. I declined, perhaps inadvisedly, mainly because I didn't want to place him in the line of fire sure to follow such an event. At the end of 2008, Israel launched a massive attack against Gaza known as Cast Lead, and Father Miguel sought to have the General Assembly condemn the attack and call for an immediate ceasefire and Israeli withdrawal. It was a difficult moment for Miguel, convinced that this was the legally and morally right thing to do, and the politically necessary action to take. But he was also confronted by the logic of geopolitics that he began to realize worked very differently. In fact, so differently that even the diplomat representing the Palestinian Authority at the time favored a milder reaction than what Miguel believed appropriate. Unlike Nicaragua, here the backers of feasibility prevailed, but in a manner that Father Miguel could never could never become reconciled to accept. I met many diplomats at UN headquarters here in New York who said that no one had ever occupied a high position at the UN with Father Miguel's manifest quality of someone so dedicated to righteousness as being a meta-political reality, as taking precedence over being politically sensible or feasible. The only possible exception is Dag Hammarskjöld, an early great UN Secretary General who apparently was assassinated for his principled yet geopolitically inconvenient dedication to peace and justice. From his private writings, we know that Hammarskjöld also developed his UN commitment from wellsprings of spirituality. Most General Assembly presidents take the post as an honorific feather in their cap, the symbolic culmination of a public sector career, spending the year presiding over numerous meetings and even more frequent receptions, but made no effort to challenge, much less enhance, the role of the General Assembly, or to strengthen the UN as an institution of potential global governance. Father Miguel took this challenge differently. He worked tirelessly throughout the year, throughout his year as president of the GA, to create occasions to offer humane alternatives to neoliberal economic globalization by hosting meetings designed to overcome existing patterns of economic injustice, taking advantage of the presence in New York of such non-mainstream economists as Jeffrey Sachs and Joseph Stiglitz. Here again, Miguel was demonstrating his grounded spirituality that combined the spiritual with the practical. I had the opportunity to work with Father Miguel on proposals to raise the profile and role of the General Assembly as the most representative and democratic organ of the UN. In part, Miguel was seeking to counter the US campaign to concentrate UN authority in the Security Council, where geopolitics almost always dominated the proceedings, and third world aspirations could be effectively disregarded. What I have tried to describe in these words is this deep bond in the life and work of Father Miguel between the spirituality motivating his conduct and the practicality of his actions and involvement in what the German philosopher Habermas calls the life world. I find it indicative of Father Miguel's deep spiritual identity that he suffered a punitive response to his life's work from the institution he loved and dedicated his life to serving, being suspended in 1985 by Pope Paul II from the priesthood because of his involvement in the Nicaraguan Revolution. Father Miguel was reinstituted 29 years later, most appropriately by Pope Francis. There is an object lesson here for all of us. In a political crisis, the moral imperative of service to the people deserves precedence over blind obedience to institutions, however august and revered. This would undoubtedly almost always be a difficult and sacrificial choice, but it was one that defined Father Miguel de Scoto at the core of his being, which he expressed over and over by doing the right thing in a spirit of love and humility, but also in a manner that left no doubt about his firmness, his affinities, and priorities, as well as his unwavering and abiding convictions. As I suggested at the outset, the daring and creativity that Father Miguel brought to the law and to his work at the UN sprung from spiritual roots that were grounded in both religious tradition and existential faith, as well as in his unshakable solidarity with those among us who are poor, vulnerable, suppressed, and otherwise victimized. Father Miguel's spirituality did not primarily equate with peace, but rather with justice and a lifelong struggle on behalf of what was right and righteous. There is no assurance that this way of believing and acting will control every development or shape the ultimate destiny of the human species. The happy ending of the Nicaragua case needs to be balanced against the prolonged and tragic ordeal of the Palestinian people, for which there is still no end in sight. Beyond wins and losses, what I think should be clear is that unless many more of us become attentive to horizons of spirituality and necessity, the outlook for the human future is bleak. Father Miguel's disavowal of the domain of the feasible and transactional is surely not the only way to serve humanity, but it is a most inspiring and historically relevant way, and points us all in a direction that is tragically underrepresented in the corridors of government and public institutions, not to mention in the back rooms of Wall Street and the maneuvers of hedge fund operators. In my language, Father Miguel Descoto was one of the great citizen pilgrims of our time. His life was a journey toward what St. Paul called a better city, a heavenly city, than what was presently controlling life on planet Earth. Thank you very much.
Well, it'd be almost rude for me to say anything except you sat through one of the most magnificent talks I've ever heard. There are just two things, and I should have made a little acknowledgement. During the time where Richard said Father Miguel was rejected by the very church that he loved and served, the Maryknoll priests, they're not an order, they were an association. I always remember that legal when Miguel would describe to me, the Pope could order or direct the orders like the Jesuits to drop Father Cardinal. But Maryknoll never dropped Miguel. And he was very proud to the end of his life that when he'd come to my office, Maryknoll Insurance would pay for it. And I never would charge him. But anyway, Maryknoll acquitted well. And although he worried about Gaza, Palestine after the 2009, one of the things that Richard was involved in was he asked me to go to Gaza as his representative. And it was a very, very difficult trip at that time and opposed by a lot of people. We had this room only for a short time, and the co-host of the event is the Leitner Center. And I'd like to ask Professor Martin Flaherty who didn't hear the talk, and I gave him fair warning, he had to prepare his response by sitting here. So I'm going to give you Professor Martin Flaherty.
Thanks very much. One response I have is I feel it's my great misfortune never to have met Father Miguel, and I think you can see why. But it is a great honor and opportunity to finally meet Richard Falk. I teach both here and at Princeton, and at Princeton where Professor Falk used to teach. He's a legend, and indeed he's a legend well outside the confines of the Princeton campus as well. And I should point out it took Kevin Cahill to make that introduction possible, so I thank Dr. Cahill for that. So I'm mindful that we don't have too much time, just a few quick observations. I'm tempted to just say what he said and sit down and leave it at that. But let me say something more, both with regard to international law in general and with regard to the legacy of the Nicaragua case in particular. I fully agree that international law does have this kind of Janus face, as does much of the rest of the law. Although, in listening to Professor Falk's remarks, I was happy at least to think that the area of international law, where I do most of my work in, is very much on the side of doing what's necessary and not necessarily what's feasible. And that is, in particular, human rights law. And let me just tell you two reasons why, in one sense, human rights law and aspects of it make no sense and are completely quixotic, and yet they are essential to pursue. Two aspects of that are, one, the highest level of human rights law is something called jus cogens. And jus cogens is an area of law that says essentially things like torture, things like extrajudicial killing, in part because those command a consensus of the world community, but in part because they are just right to prevent that. In fact, it's one of the few areas of international law where natural law still arguably has purchase. So if nations get together and try to, by treaty, restore the slave trade, or by treaty say that torture is okay, Jus Cogens dictates that those treaties would be void. Even the negotiated agreement of sovereign states is not sufficient to overcome that aspect of international law. More generally, human rights law itself is not feasible but necessary. Most international law is driven by reciprocity. Trade law, it benefits both sides. This is why most international law is both made and enforced. The laws of war as well. You treat our prisoners of war well, we'll treat your prisoners of war well. International human rights law departs from that principle. It's a reaction to the Holocaust, and it's kept alive by the movement against colonial imperialism. And basically, it says that even though I, as a sovereign nation, commit to abiding by certain human rights norms to the folks within my borders, you know, that really doesn't implicate any sort of reciprocal benefits that I would get from another nation, at least directly, abiding by human rights within its borders. And yet, not only has this branch of law flourished, at least on the books, and to an extent in practice since World War II, it is the area of law that has flourished here, you know, at Fordham and in various U.S. Educational institutions, notwithstanding the fact that it does not have this principle that drives most of the rest of international law. With regard to the Nicaragua case, there's all sorts of significances. I want to mention a few and then just briefly single out one. One is, I believe that one can say that the ICJ's boldness, and Father Miguel and Professor Falk and Professor Che's boldness in taking on this case, laid the foundation, was an inspiration for later tribunals, like the ad hoc tribunals for the former Yugoslavia and Rwanda, the ICC, and even the ICJ itself when it returned to issues like this in the Bosnia case, even though that particular decision might not have been the best it could have been. I think another consequence of the Nicaragua case was that it showed to the rest of the world that the United States and the US legal community is not necessarily the executive branch, that the US is not a monolith, and in fact there's an echo of this. I was talking to folks from other countries, human rights advocates from other countries, who said they were greatly inspired by the image of US lawyers running to airports during the first implementation or attempted implementation of the Trump anti-Muslim ban. US lawyers rushing to airports to take the cases and defend the rights of those who were being barred. And that, I think, that kind of necessary but not necessarily feasible action is something that can be traced back to the efforts of the lawyers, including the US lawyers who took on this case. There's all sorts of doctrinal consequences to the Nicaragua case. I could mention a few, but for sake of time, let me just focus on one that isn't always appreciated. And it goes to the derivation of customary international law. For various reasons, Nicaragua couldn't rely directly on the UN Charter. It had to rely on customary international law, the other main source of the four main sources of international law, to make the case that what the US was doing constituted acts of aggression, violations of jus et bellum. One very sort of technical but very important aspect of that was the ICJ decision made it actually much easier to establish and derive principles of customary international law that protected human rights and that also bolstered laws against aggression. How? What it did was it said that UN General Assembly resolutions could, which are technically not binding, could serve as a source to satisfy the two main legs required to establish a customary international law principle. One is general practice. The more nations adopt a certain practice, the more you can argue that that has achieved the status of customary international law. Before this case, it was very difficult to just say, well, if a nation has voted against torture or a nation has voted against a certain kind of human rights violation in the General Assembly, that you could count that nation as, establishing a customary international law norm. The Nicaragua case and what the ICJ court said, no, you could use those. And it was also possible to use those resolutions to establish the other leg of customary international law, which is something called opinio juris, that nations are doing what they're doing out of a sense of legal obligation. So, long story short, with regard to that, the case made it much easier for human rights advocates to cite the more democratic branch of the UN to help establish legal norms that protect the weak and powerful and those who lack a voice. And to give you just a final example of that, in what I do, what I have done, and what I teach both at Princeton and here, one of my things I focus on is assaults on human rights lawyers and human rights advocates around the world, which is unfortunately spiking these days in light of the rise of popular authoritarianism around the world, or populist authoritarianism around the world. One source to fight that are General Assembly resolutions. There are UN basic principles on the role of lawyers, there are UN basic principles on the independence of the judiciary. Technically, those are soft law. Those are General Assembly resolutions. But in part, thanks to the Nicaragua case, you can cite them not just as the sense of the world community, but also as evidence of evolving binding norms on states that violate them. And so you have at least an additionally powerful argument. And to bring things back in a sense to Father Miguel and to sort of progress that we see in Rome, just recently at the Sixth Committee of the General Assembly, there was a debate and discussion about access to justice and access to law. I'm happy to report that the only delegation that referred to these assaults on lawyers and assaults on human rights defenders, and the only delegation to cite these General Assembly resolutions was the Holy See. So in that sense, I think the spirituality that we've heard referred to is alive and well. So thanks very much.